Welcome to my YouTube channel. I am Professor Satya Prakash. In my last lecture, I started the schools of jurisprudence, and in that lecture, I discussed about the first school of jurisprudence, that is analytical school of jurisprudence propounded by John Austin. The second school of jurisprudence which we study after Austin is pure theory of law, which was given by Hans Kelsen. His lifespan is from 1881 to 1972. He was a professor of law in Vienna University. Therefore, this school is also known as Vienna School of Jurisprudence. Otherwise, it is known as pure theory of law, from the angle of the nature of law given by Hans Kelsen. Before going to the theory itself, we should know about the background of this theory. There were three factors which may be taken as the background of theory. The first is that it was a reaction against the natural law theories. In the 19th century, early 19th century, natural law theories were prominent in Europe, and because there was not such certainty as required under the law, in a sense, analytical school was a reaction against the natural law theories, including the theory propounded by John Austin, which provided certainty of law. In the same sense, the pure theory of law is also a reaction against the natural law theories, because natural law theories are based on some metaphysical aspect. So the theories in modern times, which are known as analytical approach, were propounded. Secondly, Hans Kelsen was highly perturbed due to the death and destruction in the World War First, that is from 1914 to 18, and it may be considered as his approach to avoid or to restrict the destruction due to war. Therefore, he supported public international law to the largest extent. Thirdly, it may be taken that because after the World War II, the countries which got independence adopted written constitution. So, in a sense, Hans Kelsen got support from the written constitution, and therefore he was able to propound his theory of grand norms. As regards the theory, that is the pure theory of law, he propounded 5 principles. The first is that a theory of law deals with law as it is and not as it ought to be. In this sense, it is known as positivistic approach or the analytical approach, like that of Austin. Then, secondly, a theory of law is different from the law itself. We may have a particular theory of law, or the state may have a particular ideology, but it is not necessary that the laws in force are absolutely or completely in consonance with the theory applied by the state. For example, we have communistic theory in certain countries like Russia and China, but the laws in Russia and China are not completely in according to the communistic theory. In India also we have socialistic approach of society, but the laws are not absolutely in that direction or in the direction of socialism. It is because many factors work in the implementation or application of law which are not effective in the theory itself. We approach for the implementation or application of law, and from that angle we have to plan for the future. And like in America, they have some planning of 50 to 100 years. In one sense, this may be called as futurology, which is essential for implementing a theory or transforming theory into practice. Thirdly, he said that a theory of law must have universality or uniformity, means it must be applicable in all times and at all places. It should not be restricted to some particular society. It must have the nature of application in everywhere in the universe. Fourthly, he said that a theory of law must be pure. Due to this aspect or principle, the theory is named as pure theory of law. He says that a theory must not be having impact of any other factor or sociological factor or economic factors or political factor. It must be pure in itself. There may be different or some difference in the after application of the theory, but the theory itself must be pure. It should not be based on any factor which are existing in the society. Fifthly, and the most important aspect of his theory is that he defined law as a normative science. He said that law is a normative science. Norm means a proposition or supposition or hypothesis that if one thing happens, the other is to happen. In natural sciences and physical sciences, also there are norms, or there is a concept of cause and effect. If one thing happens, the other will happen. Science norms are is norms or confirmed norms. Social science or law norms are ought norms. In science, if one thing or one event happen, the other will certainly happen unless and until there are various forces working against that particular event or action. Like if we leave an object in movement, it would remain in movement till any force is applied for restriction of that movement. Law norms are not so confirmed or certain. In law, we have ought norms, that if one thing happen, the other ought to happen. It may not happen due to certain reasons. Like if someone commits crime, he ought to be punished, but it is not confirmed that in all circumstances the person shall be punished. There may be various factors which come in the path of the end of the commission of crime, like there may not be sufficient evidence or witnesses, or even from the very beginning the culprit may not be found or arrested. So law norms are ought norms, means if one thing happens, the other ought to happen or should happen. He said that these norms are arranged in a systematic way, in an hierarchical position or in a pyramidal position. At the apex of this pyramid or this hierarchy is the grand norm or the basic norm or the fundamental norm. As I said that the written constitution in most of the recently at that time independent states adopted written constitution, it gave impetus to this theory of grand norm. At the apex, the constitution of the state or country is considered to be the grand norm. All other norms get power or authority from that norm in an hierarchical position, that the at first level after grand norm, the other norms get authority. Then from those norms, the other norms get authority, and in the end, it is being structured as in a hierarchical tree or in a pyramidal fashion, means it is broader at the lowest level, and at the apex there is grand norm. This process is a dynamic process. It is not a static process. It is a dynamic process, and this is one of the difference between Austin and Kelsen, that Austin said that the sovereign is definite and only sovereign can make laws. But in the theory of Kelsen, it is a dynamic process. One norm gets power from the other norm, and in such manner it is widened or being developed till the end norm, till the lowest norm. So there should be one grand norm in the society, but in some cases there may be more than one grand norm, but they must be in support, in consonance, in coordination of each other. Like in Britain, basically the parliament is supreme or the grand norm, but the judicial precedents and custom or convention which are recognized by the legislature may also be the basic norms of society by which the society is being run. So it is a dynamic process. In written constitution, like India, constitution is the grand norm. All the organs of a state, that is the legislature, executive and judiciary, get power and structure from the Constitution of India. Even the fourth pillar, which is known as the press, so that is also being governed by the Constitution of India. In a sense, their conduct is governed by the Constitution of India. The conduct of all individuals and their relation with the state or state organs are also governed by the Constitution of India. So in countries like India, where we have very explanatory constitution, the constitution is the grand norm. It is also so in, in states like USA, Australia or Canada, where we have written constitution. Then when we come on the basis of grand norm, Kelsen said that the basis of grand norm is the minimum effectiveness or the minimum support of the people or the subjects upon whom the grand norm is applicable. The criticism of this theory, one of the criticism is that if what is the minimum of effectiveness, and if we analyze the minimum of effectiveness or support of people, then that support is based on certain factors, maybe economic, cultural, social, educational, but the theory of Kelsen cannot be rejected on this ground, because he said that the theory is applicable till the nature of grand norm. The basis of grand norm is minimum of effectiveness. His theory does not go beyond the grand norm or the basis of grand norm or the various factors which are applicable for the basis of grand norms. So, in this sense, the important point is that a theory of law must be pure, a theory of law must be universal, a theory of law deals with law as it is, and a theory of law is based on grand norm, or law is a normative science. And then what are the implications? The implication of this theory are, firstly, there is no distinction between public and private law. Public law means the law related with the state or state organs, like the constitutional law, administrative law or criminal law. And the private law means at one place the laws which deal with the rights and duties of individual interest. In public law, there is regulation of relation of the organs of state and the relation of various organs of state with the individual or the people of the state. In private law, there is conduct of relation of the individual themselves, though it is regulated by the state laws, but they are known as private law. In wider sense, the terms and conditions developed by the individuals may also be taken under the private law. Secondly, there is no difference between right and duties, because all are sanctioned by the grand norm and the further norms which get power from the grand norm, whether it is right or whether it is imposition of duty. Thirdly, there is no difference between national law and international law. This is a very important point of the theory propounded by Hans Kelsen. As I said, one of the background of this theory was that there was destruction, mass destruction and death due to World War. So this theory was propounded in 1961. This theory was propounded in 1934. So after the First World War. So he supported international law in an absolute manner. He said that when he said that there may be more than one grand norm in a society, but they must be in consonance, in coordination or support of one another. He said the grand norm of various national laws and the public international law may be different, but they are in support of each other. Otherwise, had they not been in support of each other, one of the grand norm would have been destroyed, the weaker grand norm would have been destroyed by the stronger grand norm. When international law and national law are existing at the same time, in the same place, it means they are in consonance or in coordination with one another. Therefore, he gave monistic theory. He supported monistic theory of relation between international law and municipal law and gave pluralistic theory about the relation between international law and municipal law. Means there is plurality of grand norms of all the member states of international society and grand norm of international society or public international law, and therefore because they are existing at the same time, so there is no difference between international law and municipal law or national law or state law. So then there is no difference between natural and juristic person. Both the natural person means the human beings, which are the units of rights and duties. Person means a unit which has right and duties. Generally, human beings are the natural person. They are person by birth only, but at the same time, there may be artificial person or persons which are not human being, like corporation, but they are given the status of person by the authority of state. So he supported the bracket theory or realist theory of personality, that artificial person are also, that is a collective status of people. Only in artificial person also the natural persons are involved. Therefore, there is no difference between natural and artificial person. Both are given. A human being or a natural person who has not been given rights or duties by the state may not be considered as person. Like the lunatics, or a person of unsound mind, or a minor for some aspect, like a minor cannot enter into a contract. So though the minor is human being or natural being, but he or she does not have power to enter into the contract because it is not given by the state. So every right and duties, whether related to the human beings or individual or natural being and the artificial being, is given by the state. Therefore, there should not be considered any difference between the natural person and artificial person. Then there is no difference between legislature or legislation, precedent and custom or convention, because all the three sources of law get power from the grand norm. Unless and until the three sources of law are recognized by the state law or grand norm, they cannot be treated as law properly and cannot be applied simultaneously. So, there is no difference between legislation, precedent, and custom. Then there is no difference between law and state, because both are the depiction of grand norm. The state is being run or having authority by the grand norm, and the laws made by the state, the competent authority of a state, is also made by or under the authority of grand norm. So, law and state are same. It is akin to the one of the concept or doctrine of the economic approach, that is identity of law and state. That law and state are same, and from the economic approach given by Karl Marx and Friedrich Engels, it means that whatever is the character of a state, that would be the character of law. But the difference is that in Kelsen theory, both get power from the grand norm, or in societies where we have written constitution, from the constitution. They cannot change the laws as per their wishes or their whims. They have to make laws under the constitution. Like we have secular socialist democracy. So we cannot, the government of the day or legislature, because we have parliamentary form of government, so there is no much difference between the legislature and the executive. Executive is responsible to the lower house of parliament, though if they don't have majority in the upper house, they cannot make laws. But even if they have majority in both the houses, even 2/3 majority, they cannot make such laws which they think proper, but which are not in consonance with the constitution, which provides a democracy which should be secular and social. So, this is the difference between the economic approach by Karl Marx and the approach of Kelsen. Then, seventhly, there is no difference between substantive law and procedural law, because both are being made under the authority of grand norm by the competent authority or organ of state, that is legislature. And again, there is no difference between executive, legislature and judiciary, because all the three organs of state are given authority or power and also responsibilities by the grand norm or basic norm or fundamental norm, that is the constitution of the state, specifically in the constitution of India. When I said that it was a reaction against the natural law theories like the school propounded by Austin. But there is a difference between the Austin and Kelsen theory. Though both are being covered under the analytical approach because they study or analyze what is law. The first is the difference between norm and command. From the angle of Austin, the law is given by some authority which is over and above the subjects or masses in the society. But in norm theory or Kelsen theory, the laws are made and they get power from the ground norm. If they are not in consonance with the ground norm, they cannot be treated as proper law. Whatsoever or whosoever may be the authority making law, the laws must be in consonance with the ground norm. So there is nothing like some external body who is making law. The lawmakers or lawmaking authority is part of the system or dynamic structure of the normative science, and they get power from the ground norm. Secondly, the sanction. Austin said that law is the command of sovereign. Means there is something, command means a duty enforced by sanction. So the sanction is, it looks that sanction is something like an external factor which is responsible for the implementation of law in Austinian theory. In Kelsen theory, there should not be any factor which is external to the structure of norms. So here one norm or one law at the lower level gets power from the law over that law and ultimately from the ground norm. So the sanction is not something which is outside the structure of the laws or the structure of the norms. If we have some external factor as sanction, then the theory will become impure, because Kelsen says that there should not be any factor besides the theory. The theory must remain pure. So if some external factor of fear or punishment is involved, then it would not remain pure theory. The sanction is within the structure of norms. So, and therefore it is a legal dynamics. In Austinian concept, the process is static, that sovereign makes laws and it is implemented by sanction or the evil consequence of punishment on the subjects. But in Kelsen pure theory of law, it is a dynamic process, and every time one norm is getting power from the other norm and it remains working with the structure of the normative science. So it is a dynamic process, and therefore it is not a purely certainty. Austin says that there may be certainty in law, but in Kelsen theory These are the ought norms or hypothesis, supposition, proposition, that if one thing happens, the other shall happen. So, this is all about the pure theory of law propounded by Hans Kelsen, and also the main differences between the Austinian theory and pure theory of law. In my forthcoming lectures, I would further deal with the schools of law, and third school in this sequence is historical school of jurisprudence, in which I would discuss two thinkers. One is Chevny, who propounded the theory of Volksgist or common consciousness of the people, and the other is Sir Henry Maine, who is considered to be the propounder of anthropological approach to law. So, with these words, I end today's presentation, and thank you very much and all the best.